Before I get to introductions, I'd like to recognize a couple organizations, the first being the Nackey S Loeb School of Communications. Executive Director Laura Simones is magically working all of the logistics to make this program happen. So many thanks to her and for the Loeb School for really providing the infrastructure for today's webinar. I'd also like to recognize the New Hampshire Press Association, led by President Phil Kincaid, who is here joining us today. Many thanks to the Press Association for all their work helping get this program to where it is today and to get the word out and make sure that all of you knew that we were having it. So thank you to Phil, Laura, the Loeb School, as well as the Press Association. So now to our featured guests. We have two speakers here today. The first is Rick Gagliuso. He's a member of both the NEFAC and New Hampshire Press Association Board of Directors. Rick is an established construction law authority, a media attorney, a civic activist. He's also a partner at Bernstein, Shur, the law firm in Manchester. Rick represents media outlets throughout the state and is going to be a great resource, I think, for everyone after this webinar. Greg Sullivan as well joins us. Greg, too, is a member of the NEFAC Board of Directors as well as the board for the Nackey S Loeb School. Greg serves as general counsel for the Union Leader Corporation. He also teaches First Amendment law at Suffolk University Law School in Boston, where he taught me many, many years ago. And he also teaches at the Loeb School here in Manchester. So Rick, Greg, thank you both for joining us, and hello to you both.
Thank you, Justin.
Hello, thanks, Justin.
So the two cases that we're going to be discussing today are Seacoast Newspapers versus City of Portsmouth, as well as Union Leader versus the Town of Salem. As I mentioned, both ended up in the New Hampshire State Supreme Court, and the decisions that resulted really have significantly affected the state's right to know law. For those that don't know, the right to know law determines what public records we're entitled to as citizens, not just journalists, but all citizens, what kind of government transparency we are privy to because of that statute. And these decisions really had some important implications. Rick, let's begin with you. You were among the lead counsel for the Seacoast case. Can you tell us about the facts in this case and how it proceeded over the last 2 years?
Yeah, thanks, Justin. Maybe before I get to the facts of the Seacoast case, let me just do a quick summary of where the law was before these cases were decided, because it's kind of important to understand where we came from and to figure out where we are now.
That'd be great.
For those for all of you, journalists who have been interested in records pertaining to individual public employees, their performance, their discipline, and so forth, there have been two exemptions in the right to know law that have applied to requests for those records. One of them was an exemption for internal personnel practices, and the other one was for personnel files whose disclosure would constitute invasion of privacy. As many of you know who have been down this road, the internal personnel practices exemption has been construed by our Supreme Court for years, going back to the early 1990s, as pertaining to individual personnel matters, such as performance, discipline, compensation, and so forth. And it's been interpreted up to now as a categorical exemption, which means that there is no balancing of interests involved. It's just they're categorically exempt. And so, as all of you know who've made requests for records like this over the years, you kind of have the door slammed in your face quickly by agencies, police departments, and other public agencies who have said, oh no, this is an internal personnel practice and it's categorically exempt. We don't care how strong your interest is in it, and we don't care what privacy interests may exist. It's just exempt under the right to know law. And unfortunately, that position found support in the cases that the Supreme Court has decided beginning in the early 90s and up through very recently. The agencies would often cite the personnel file exemption as well, sort of as a stopgap or backup. But what they really hung their hat on typically was the internal personnel practices exemption. And as I say, it was just a, slam the door in your face. So the Seacoast newspapers case with the city of Portsmouth arose out of an arbitration proceeding involving a former police officer in Portsmouth who went through arbitration under the collective bargaining agreement between the police union and the city, and where the arbitration resulted in one or more awards. And Seacoast newspapers requested access to those. And of course, the request was denied, largely on the basis of the internal personnel practices exemption. They went to court, and the trial court, the Superior Court, upheld the city's position and said, no, this is an internal personnel practice and it's exempt from disclosure. So that's what brought us in front of the Supreme Court. And it was a wonderful opportunity for us to argue that this internal personnel practices exemption had been misconstrued years ago, and that erroneous interpretation had been sustained and maintained for years since then, all incorrectly. And we argued that the internal personnel practices exemption, unlike the personnel files exemption in RSA 91A5, by the way, that's where these exemptions are, Section 5 of the Right to Know Law, had the internal personnel practices exemption was really intended to cover rules and practices and policies having to do with personnel. We went back to the Freedom of Information Act, which is the federal counterpart to the Right to Know Law, and we looked at their counterpart exemption and the way it had been interpreted. And we argued, I think fairly convincingly, that exemption was never intended to apply to individual personnel matters, employees, but it was intended to apply to rules and policies. And the federal case law that we cited talked about things like policies pertaining to sick leave or vacation time, or where do you park when you get there in the morning, which is obviously very different and far narrower than the way the Supreme Court had interpreted that exemption up to now. So Seacoast Newspapers versus City of Portsmouth, which was decided at the end of May, along with a companion case, Union Leader Corporation versus Town of Salem, which Greg's going to chat about. But the Seacoast Newspapers case took the opportunity to accepted our invitation, basically, to overrule the cases that had interpreted internal personnel practices incorrectly for so long. There was if you get a chance to look at the decision, there was a long discussion of a doctrine called stare decisis, which has to do with the need to maintain stability in the law and the reasons why you don't lightly overrule prior case law. The court dealt with that head on and said, no, this is something that was wrong way back in the 90s. It's been wrong since then, and it's time we fixed it. So Seacoast Newspapers and City of Portsmouth now says that the law, the Right to Know Law exemptions are really very different from what we've all understood them to be. Internal personnel practices, they adopted our argument and the federal case law, saying internal personnel practices is actually a very narrow category of documents having to do with rules and policies and practices of a public agency and not individual employees. The sort of takeaway from that is, if you find yourself asking for a record pertaining to a particular public employee, it's by definition now, I believe, not going to be covered by the internal personnel practices exemption, because that has to do with general application rules and policies and not individual employees. So point one from Seacoast newspapers is the internal personnel practices exemption does not apply. It cannot be relied on by public agencies to exempt records pertaining to internal employee discipline, performance, and other personnel records. The applicable exemption to those records is now clearly the exemption for personnel files. But personnel files in the law is qualified by whose disclosure would constitute invasion of privacy. And so it's very clear now, and the court made clear that there's going to be a balancing test employed to determine whether or not those records should be disclosed. We really wanted to do this webinar today to give you not only what the law was, but something of a user's manual for these cases, and make sure that journalists in New Hampshire now understood the new toolbox that they have to work with. For those of you who have assumed for years that you're going to run into this brick wall of internal personnel practices whenever you ask for anything having to do with a particular public employee, whether it's discipline or performance or anything else, there's a new sheriff in town. It's that exemption is no longer going to apply, and it's no longer going to give public agencies a chance to categorically deny access. The correct analysis now is going to be, is it a personnel file? Is the record you're looking for part of a personnel file? And if so, does the public interest in disclosure outweigh whatever privacy interests may exist in it? So understanding the way this is going to work, you're not going to be automatically entitled to personnel records and files, but you are going to be now clearly in a position to argue that the public interest in disclosure of those records outweighs any privacy interest that exists.
For you, Rick, just a point of clarification. So Arthur Green's asking, why did we have the secrecy in the first place? What was the public benefit that was argued initially for keeping personnel records like this secret and withheld from the public?
Yeah, the rationale for those decisions was, I think, pretty sketchy, but basically was that keeping those records private would encourage people to come forward, within public agencies, whistleblowers, if you will, and encourage them to come forward and speak up with some understanding that whatever they had to say might be protected. I didn't find that to be a very compelling rationale then. I certainly don't now, but that's what it was. It's a good question. That's what it was years ago. And the court in the Seacoast newspapers case sort of alluded to that and said, yeah, that's, we're not buying it. So the one thing I wanted to add, and then I'm going to turn this over to Greg and answer some questions, because I really do want mostly to take questions. But here's the one final point I want to make about personnel files and the balancing test. We made an argument in the Seacoast newspapers case that if the court saw fit to overrule these cases that had interpreted the internal personnel practices incorrectly, that they should then proceed to balance whatever public and private interest there might be in the disclosure of these arbitration awards. And we argued that public employees have no legitimate privacy interest in the performance of their job. The court declined to do that balancing on an appellate level and sent it back to the Superior Court for that to happen. So we're going to be fighting that issue out in Superior Court shortly. But our argument has been, and is going to continue to be, that public employees have no privacy interest when it comes to how they're doing their job. Yes, do they have a privacy interest in, records that contain social security numbers and medical, reports and things like that? Sure. And we would expect that those kind of records will be removed or redacted from anything that's being disclosed. But when it comes to performance and discipline of public employees, our argument is that there is no privacy interest at stake. And we have some good case law from other places. So that, Greg and I were talking just recently, that's going to be Seacoast Newspapers Roman 2 or whatever whoever it's going to be that lets us bring that case up. But I want to try to establish clearly that there's no privacy interest at stake when you're talking about employee job performance. So that's the lay of the land as I see it.
So we have some questions about how this relates to journalists in particular and some suggestions for them, and we'll get to those in a moment. I want to turn to Greg now. Greg, on the very day that the Seacoast decision came down, so did the union leader case. Can you tell us about that case and the facts that were involved and why that's either distinguishable or complementary to the Seacoast case?
Sure. They totally complement each other. They were argued on the same day, back to back, along with a third case that we haven't mentioned against the city of Keene, which the Supreme Court also ruled in favor of the petitioners seeking information about the performance of government agencies. I want to take the opportunity not only to thank all the people who put this together, but Gilles Bissonnette from the New Hampshire ACLU, who worked on these cases with Rick and I, argued at the Supreme Court, couldn't be with us today, but did a great job, as did Rick, as did the Supreme Court, finally. This case, the Union Leader versus Salem, involved a audit that was performed by a nationally recognized authority on police affairs. It's 177 pages dealing with issues such as abuse of time, vacation time, double shifting, in other words, working your regular 7 to 4, whatever it was, and also working details at the same time. It also dealt with the culture of the police department, and it also dealt with specific instances of alleged employee misconduct, which the audit report concluded the Salem Police Department was not doing a good job in reviewing these complaints and handling these citizen complaints. So as Rick has pointed out, these things under the decision of Union Leader versus Fenneman, which was 1993, had been per se exempt from disclosure. I argued the Fenneman case unsuccessfully in 1993, made the same arguments in 2020. This time we prevailed, and obviously there's not only a different Supreme Court panel, but a different atmosphere across the nation. Obviously, these cases couldn't be more timely relative to police misconduct. But I do want to point out that the public having a right to know what these documents contain often will exonerate police officers' reputations, give praise where it's due. So the light of public scrutiny is not just to show Officer A is doing a bad job, but perhaps Officer B is doing a great job. And this, the public has the right to know. Every time I speak about right to know, I start out, as you know, Justin, with a slide of the US Constitution starting out, we the people. We own the police department, we own City Hall, we own the White House. We are the government, and we have the right to know how our servants and agents, which is all government employees, are doing their jobs. So these two cases, these three cases really, are monumental in terms of New Hampshire jurisprudence. We now have the right at least to have the balancing test that's been applied historically to other governmental records relating to finance, for example. Interesting to me, in 1996, in the case of Union Leader versus the city of Nashua, the Supreme Court ruled an individual, a citizen's privacy right, will take a back seat if the information will disclose information about the performance of a governmental agency. So they applied that in 1996 to ordinary citizens, but it took until 2020 where that same test is now going to be applied to government employees.
And just to clarify, Greg, for everyone, even though both cases dealt with law enforcement records, these rulings apply to all personnel records, correct? It doesn't have to be specific to police by any means. It can be related to any public employees. Is that correct?
Across the board, as the journalists in the audience know too well, there are many agencies and municipal employees who, at the Stonewall, saying these are internal personnel practices, and they've been able to do that from '93 until this year, and that's now out the window.
Mm-hmm. So teachers, for example, anyone who's in who's a public employee, we're talking about their records, correct?
And that's what here in New Hampshire, we have a Part 1, Article 8 of our Constitution, which makes all governmental employees, again, our servants and agents. It's stronger even than the First Amendment, not to mention the preamble to the Right to Know law, which says that we, the people, have the right to know how our government agents are performing.
So help us understand, Rick, give us your thoughts. You mentioned a toolkit or some suggestions for the many journalists that we have with us today. How can they use these decisions in their work? So for example, one question that was posed in future right to know law requests, should that balancing test argument be made, or should some other tactic be followed? What do you suggest?
So, yeah, this is really why I wanted to do this today, to have a chance to at least offer some practical advice about how to use these cases. All of us have to change the mindset that we've had now for a long time, which has been, the sort of general knee-jerk reaction that, gee, when we're seeking records pertaining to individual employees' performance, discipline, and so forth, yeah, we're not going to get those. No point asking. The message that I have for people today is there is a point now in asking, and we all need to get our minds around the idea that those kinds of records are no longer categorically exempt from disclosure. So what does that mean? I think you need to be thinking about when any public agency that you're covering, whether it's a school district or a state agency or a municipal, planning board or whatever it is, there's a whole universe of records pertaining to employees now, public employees, that are fair game. And it doesn't mean that you're going to get them necessarily, but it means you ask. And my message to everyone here today is start asking. Start asking for these records. It's not clear to me, and it's going to take, I think, a little time to shake out how agencies are going to respond to requests like that. Are they going to, and here's my big question is, are they going to conduct that balancing on their own, or are they going to leave it to courts to do that? My hope is, and my argument is going to be, that they should be doing it on their own at an administrative level. And when it's clear that the public interest in disclosure of any record outweighs any privacy interest, that they disclose it. What my fear is, frankly, is that a number of agencies may do just the opposite and say, we're not going to make that call. We're going to tell you that there are countervailing privacy interests at stake, and if you want them, go convince a judge. And we'll see. We're going to have to see how that all shakes out. In the Portsmouth case, I can tell you, after the Seacoast decision came down, I contacted the attorney for the city of Portsmouth and said, okay, when do we get these arbitration awards? And the answer was, oh, we're going to let the court figure that out, meaning on the remand to Superior Court. So, if that's the way agencies respond to these requests, we may find ourselves back in court arguing this balancing test that Greg was talking about. My hope is, is that they'll conduct that balancing at least initially on their own, and all of us here have to be prepared to argue that balancing and argue the strength of the public interest as opposed to any privacy interest. And that's where what I was saying before about public employees not having a privacy interest in their own job performance, that's where that argument is going to get made, that you don't get to argue, gee, how I'm doing in my job is my business and not yours. That's the argument we need to make.
So is that an argument that you would suggest we all make in our requests moving forward, even citing these cases? Or let me add to that, requests that have already been made, is it worth following up with those with a copy of the decision and saying, hey, look, I am entitled to this information after all? How should we proceed with the requests specifically?
I mean, I don't know about Greg, but I've already written letters asking for agencies to reconsider prior denials of requests for records like this. So that, I think, is something we should be thinking about. I guess I haven't thought this through completely, but I guess my thought is that your initial request is probably going to look a lot like it did before. But when you get the answer back, oh, internal private, personnel file, you don't get it because it's in a personnel file. Then you push back and you say, no, the public interest clearly outweighs any privacy interest here. I suppose you can do that preemptively or upfront as part of an initial request. But either way, I think you need to be prepared to make that argument at some point.
Thanks. Greg, general question for you. Someone's asking, well, in order to get this type of information, can I just ask for the entire personnel record, or do I need to have something more substantive or specific to base my request on?
One thing I learned early on, every case turns on its own set of facts. But no, you're not going to just say, I want someone's personnel file. A balancing test is going to be applied, and you need to have a reason that you believe some information in a particular employee's personnel file is pertinent to job performance that the public has the right to know about. I also want to mention, while we have time, there's another case pending before the New Hampshire Supreme Court, Union Leader versus the Department of Justice and New Hampshire ACLU versus the Department of Justice, that was done together. And that relates to what we know as the Lorry list. And that case is yet to be argued and yet to be decided. We were scheduled to argue it in March, and obviously it was postponed due to the pandemic. So we hope to be arguing that case soon, and I anticipate it to be another significant victory before the Supreme Court. If a police officer is even accused, or in the case of the Lorry list, it's been substantially proven that that officer is guilty of misconduct, the public has the right to know who those officers are. And that's pending.
Sounds like we have another webinar in the making. Rick, question for you regarding personnel files generally. Can they, if the employee is no longer employed, if it's a former employee, do those files exist, and for how long? Can we ask for these records going back many years, or is there a cutoff at some point where that public access ends?
There's no limitations period on right to know requests. The only issue there, I think, is going to be how long are public agencies going to retain files like that. And I suppose, there's a point where they may no longer be available. But as long as they're available, whether it's a current or former public employee, you're entitled to ask for it anytime.
Yeah, I'm going to jump in if I can, Justin. In our pending Salem case, some of the officers involved, we believe, will be disclosed as guilty of misconduct, are no longer on the force. But we're not talking about those individuals. We're talking about governmental records.
And by the way, there's another public interest involved here that everybody needs to keep in mind. When you're asking for, disciplinary records or records pertaining to an investigation of possible misconduct, it's not only the public employee who's the subject of that investigation or that discipline that you have an interest in, but you have an interest in the way those kind of complaints and issues are handled. So, it's not just that we're trying to shed light on the performance of Officer X from the Concord Police Department. We're trying to shed light on how the Concord Police Department handled that complaint and handled that issue of misconduct, apart from what it says about the officer himself. So, there's a very strong public interest in these kinds of files, and everybody here who's going to be looking for that stuff needs to keep in mind that we're trying to look at how public agencies are responding to issues like this.
A question I have here, Rick, is just how those agencies respond. Who ultimately has the authority to release these personnel files or the information that's in them? So if, for example, we make a request of a police department and it's denied, can another government official in some other agency, can the mayor, for example, release that information on their, on their own initiative? Ultimately, who has the authority to determine, hey, this information's in the public interest and we're going to release it regardless of whether it was initially denied or not?
That doesn't come up very much in my experience anyway. I guess what I would tell you is, as a matter of legal authority, I suppose it depends on what kind of political subdivision or agency we're talking about, and whether a mayor or board of aldermen, for example, may have authority to overrule a police chief or a police department. I suspect in some cases they do. I think as a practical matter, you're not going to find people overruling agency decisions like that very often.
I want to get back to the process. And again, for everyone who's joined us today, again, thank you. And please do continue to write questions into the chat box, and I'll get to them as soon as possible. But I'm interested in the process. Rick, initially you mentioned, the issue of stare decisis and how we had many years of right to know law that we were asking the court to overturn. As an attorney representing a media organization, how do you approach that process? I mean, this started, what, 2-3 years ago, I believe, right? And I would have to admit that maybe you had in mind, this is an uphill battle for me. Maybe you didn't. Maybe you saw victory. But what was going on in your head years ago when you started this case, knowing that we're going to have to overturn some law here? We're making a big ask.
I mean, you always enter into something like this knowing it's an uphill climb, because courts generally are disinclined to overturn established case law. And we knew that there was going to be a strong argument by the people opposing our case that, look, you shouldn't be messing with the law that's been in place now for decades. And there is New Hampshire case law. I won't get into the details of the factors that a court's supposed to consider in considering whether to overrule prior case law, but there is pretty well established case law in New Hampshire that guides the court in determining whether to overrule prior decisions. Here, we knew that we had not only a decision to overturn, but the Fenneman case, as Greg mentioned, had been followed and followed and followed, not only by the Supreme Court, but by countless trial courts and agencies around the state. And so we knew that there was going to be that argument that, hey, don't mess with this. It's been in place for too long. But I think, at least on my part, and I don't know if Greg had different thoughts, but on my part, it was, I in researching the counterpart exemption in FOIA, in looking at the legislative history of the right to know law going back into the late 60s and early 70s, I was convinced that the Supreme Court had messed up Fenneman. And, you know, I thought we needed to take a shot at convincing them that they had messed up. You know, it's not that easy to look judges in the eye and say, you know, that decision you made 27 years ago was really screwed up. And yet that's kind of what we had to do. And, and we did it as respectfully as we could, but not pulling any punches, you know, and we didn't shy away from arguing that it just was wrong and it was time to fix it.
Well, I'm glad you made the arguments you did. How was the experience for you, Greg? I mean, how do you approach the task of arguing to state Supreme Court justices, hey, you got it wrong, this needs to be fixed?
Well, fortunately, the justices we were arguing in front of in 2020 were not the same justices in 1993. So during the argument, I mentioned this to Rick recently, everyone was arguing about Fenneman, and I stood up and said, I'm intimately familiar with the Fenneman case as I argued it before this court. And Justice Hicks said, oh, so this is all your fault. And I said, no, it's the fault of the Supreme Court, present company excluded. And they got a little chuckle out of that. And, you know, times change. And Rick has mentioned the federal case law, which was on our side. The Vermont Supreme Court, the appeals court in Massachusetts, and the Worcester Telegram case, which we cited, just had terrific language about the citizenry should not be treated as aliens with respect to police departments, but rather the more the public knows, the more public trust and confidence can be built into the relationship between the citizenry and the police department. So, I mean, I argued Fenneman was wrong then and it's wrong now. And the atmosphere certainly has changed. And that's with respect to lots of area of the law. I argued for so many years for cameras in the courtroom in New Hampshire. And I was having lunch once with the Chief Justice of the Superior Court. He said, yeah, there'll be cameras in the courtroom over my dead body. I mean, that was the resistance that we had for many, many years. Times change. Cameras now are in courtrooms throughout New Hampshire. Not yet in federal courts, interestingly enough, but that too will come. One of my heated arguments with the Committee on the Judiciary and the media over cameras, that at the time, Chief Justice of the Supreme Court, Netto, pulled me into a side room and was laughing at me and said, relax, it's gonna happen. It just takes time. So that's what happened with Fenneman as well.
Great.
Let me, Justin, if I can jump in and say,
please.
Sorry, if I can just jump in and say something that I didn't want to end today without remembering to say. You know, we wouldn't have a chance to do these kinds of things if we didn't have clients like some of the people who are on with us today, the people from Seacoast newspaper and the people from Union Leader Corporation and other media entities around the state who need to have the guts and in some cases, in most cases, the money to fund these kinds of efforts and push them. And, you know, these guys deserve enormous credit, in my view, for taking the lead on issues like this.
If I could add to that, Rick's totally correct. But additionally, the reporters that I've seen over the years, I'll mention one because he deserves it, Mark Hayward of the Union Leader. I think his middle name either is or should be Relentless, because he has banged his head against the walls of cities and towns and the federal government for so many years. And as I said, we've over time been able to really expand the public's right to know.
Absolutely. No, a lot of credit should be given to the media organizations behind these cases. I'm wondering, Greg, for those that are joining us who are not journalists, what kind of stories are we more likely to see now? What kind of reporting do you expect to see now because of these cases and the investment that's been made in this litigation? Well,
you know, it's a nationwide movement to you know, in some cases really restructure, I'll say, police departments, but certainly to open up, you know, if there's 99 excellent police officers and there's one bad apple, we need to know about that. We need to know who it is. And as Rick said, not only who it is, but how have the supervisors responded? Have they installed appropriate discipline, or have they swept things under the rug? So based on these 3 recent cases, and hopefully the Laurie's List case coming up, the public's going to be able to know far more significantly about the workings, not just of police departments, but all governmental agencies. They work for us.
Do you see a trend toward transparency? Greg, you mentioned cases that are in the pipeline that we're still waiting on. Do these decisions that we're discussing today make you optimistic that we'll get favorable decisions on those?
There's no question about that. These 2 decisions we're talking about today are monumental in terms of the public's right to know what the government is up to. It's a whole new arena.
How about you, Rick? Do you share that optimism?
Absolutely, and that's why I'm trying to encourage people here today, and I'm going to continue to preach this going forward. There couldn't be a better time to be investigating these kinds of things and looking into this stuff that involves the performance of public agencies and employees. Now's the time. You've got a great climate. You've got a great Supreme Court who's receptive to those arguments. There's still work to be done, as I say, in sort of refining the privacy interests that people are going to be arguing about. So there's still work to be done. There's still cases to be argued. But my goodness, there's no better time to be looking for records like that. And as I say, it's so important to me that people leave here today with starting to make that shift of mindset from, no, we're not entitled to this stuff, to, yeah, we really are, and start asking for it.
So that's great news within the courts. I have one person saying, though, you know, it's sad that we have to actually litigate these matters. What's wrong with our representatives? Why can't we just enact better laws that will, you know, require transparency? Why do we have to go to court, you know, to begin with? You know, do you have any suggestions for citizens, journalists, and otherwise on how they can really push for transparency moving forward? So news organizations don't have to spend their money and time, and attorneys like you don't have to be in court every single day making these arguments. We can just have the transparency that we deserve from the beginning.
Yeah, you know, there are some changes to the right to know law that would be enormously helpful and valuable. And people like David Sod from Right to Know New Hampshire are out there constantly, you know, pounding the pavement trying to implement some of those things. I have been pushing for a while for a change to the right to know law that makes it easier to recover legal expenses when you prevail in a case under the right to know law. I think if there were one change I could make, that would make a difference in the way public agencies respond to these requests. It would be changing the right to know law to make it clear to them that if they withhold things and it's found that they should have disclosed them, they're going to pay. But right now, that's not the law. So yeah, you know, we're asking not only journalists and citizens have to change their mindset a little bit, but keep in mind, I mean, we are dealing with decades of law that has supported resistance to disclosing records like this. It's not gonna change overnight. The law changed overnight, but the mindset and the approach of people is going to take some time and some work, I think.
Greg, do you have any thoughts on how we as citizens can really push for more transparency and change that mindset that Rick mentioned?
Well, as Rick just mentioned, it's been difficult historically for the petitioner, the person seeking the records, to get attorney's fees. But these 2 cases now certainly are, because you are entitled to your attorney's fees if the government agency knew or should have known that the record should be disclosed. These 2 cases are going to make it very clear to a broad categories of records that these municipalities, the state, should know now that these records are accessible, and if they fail to comply, I do see attorney's fees being awarded.
Excellent. Well, before we wrap up here, I did have one additional question going back to police records specifically. Do either of you know if there are any plans to ensure that these rulings that we're discussing today are taken into account when police reforms are being discussed? What's mentioned here is the Governor's Commission on Law Enforcement Accountability, Community, and Transparency. I don't know much about that particular commission, but it seems like one of the many efforts right now to look at various policies within law enforcement agencies and see where reform can occur. Will these rulings have any place in those conversations? And if not, how can we make sure that they are?
I think the statute, the right to know law, needs to be amended to include the governor and commissions specifically set up by the governor, because the governor's office today would argue that all those records are exempt from disclosure. So that may be another battle, but certainly the legislature could square that away. But you know, these changes, as Rick said, they don't happen overnight. They do take time. I learned that, as I said, with respect to cameras in the courtroom.
Mm-hmm. Right. Rick, any final thoughts before we wrap up?
You know, I think we are fortunate in this state to have a wonderful, aggressive, responsible press. And I know I don't need to say this, but I'm going to say it anyway. Go out there and ask for this new universe of records that's now open to you. Think about stories that you can write that will be based on that kind of stuff. Go after it. Be aggressive about arguing the public interest. There's a new world of records that's open to us, and I'm really hoping and encouraging the press to, you know, to go after them. And for those of you who are on today, please spread the word among your colleagues and you know, other people at the media outlets and so forth that you work with. We need to have everybody thinking along these lines now.
Thank you. Thank you both. And for anyone who didn't have an opportunity to ask a question or whose question I didn't get to in today's program, in a moment, I'm going to put up a slide with everyone's contact information. You're more than welcome to email Rick or Greg or contact myself, Laura, or Phil with any of these questions, and we can make sure that we get answers to them. So please don't hesitate in reaching out. But again, I want to thank Rick and Greg. Great conversation here. Congrats again on these wins. Very important decisions, and really appreciate the two of you taking time to break down the cases for us and help us get a better understanding as to what was decided and why. Justin, as you well know by now, trying to get lawyers to talk about cases they've won is not very hard. Good. I'll make sure to sign you up for future programs going forward. Glad you volunteered.
On both these cases, I want to point out they're both headed back to the Superior Court on remand. So the fight's not over. We won a huge battle, going to make it a lot easier to win the ultimate war, which is the public has the right to know what the government is up to.